Today we're going to have a brief discussion on environmental offenses. Now, these environmental offenses are just a subset of what we can call regulatory or administrative offenses. Now, what ties all regulatory and administrative offenses together is that they embrace the concept of strict liability, which is a concept that we have covered in the past. So let's take a classic example of a regulatory offense, which is a parking violation. If you park your vehicle in the wrong spot, you may get a municipal parking ticket. Now, putting aside the idea of a consistent, repeated violator with parking violations, the idea is what's the offense once the punishment is paying a monetary fine, paying money for the consequence of breaking this regulatory offense. This is opposed to a criminalized version where you could have more serious penalties issued. Now, environmental offenses often take on this type of regulatory approach, and we've seen this when we've discussed environmental offenses under the Alberta Environmental Protection Enhancement Act, under the Federal Migratory Bird Protection Act. And what this is you only have to prove that the act occurred. So causing pollution, who caused the pollution, we can discover who it is, we can prove that pollution came from this individual, that's it. We don't need to prove anything like intent or negligence in order to make out the claim. And that's what we mean by regulatory offenses. We'll primarily have a discussion about these offenses in Canada, but we'll also contrast them briefly with the same type of offenses in the United States and the United Kingdom. This is quite a generalization, but if we look to the readings in the textbook, it would hold to be true that environmental regulation across the United Kingdom, US, and Canada consistently uses a regulatory approach, or we can call administrative rules as used in the United Kingdom. In the United Kingdom, these environmental rules are meant to give the prosecutors much discretion in determining when the offense has been made out. So there's great flexibility in bringing forward charges, and it's on a case-by-case basis. Compare this in the US, that legislation is strictly set out to be enforced. Compare this in the US, where the legislation is set out in a way that all offenses should be punished and prosecution should be brought to bear. There is some discretion, but less so than in the United Kingdom. Canada is more closely aligned with the US approach in this regard. However, Canada, for a constitutional reason, always has to allow a due diligence defense when it comes to any form of a strict liability offense, whether that be environmental or otherwise. We've already given the example of pollution as a form of an administrative violation when it comes to environmental regulation. Well, that's a substantive offense. Substantive means that the activity was actually done. There's other forms of administrative rules when it comes to environmental regulation. For instance, there's certain requirements to report information. In particular, when a regulator is doing an investigation, let's say into some sort of an oil spill or other event that occurs, failing to notify in a timely fashion the regulator of that activity can in and of itself be a violation of administrative rules. In the same way, reporting offenses can also be related to information offenses, such as concealing or falsifying information. An example occurred with British Petroleum when they had a blowout in 2010 in the Gulf of Mexico. None of the directing minds of the corporation, such as the CEO or other officers, were ever accused of violating any environmental rules. However, some employees have been charged and convicted of perjury because they falsified or concealed information during the investigation that occurred. So very similar in many ways to the reporting offenses. Finally, regulatory offenses can also be a failure to obey by orders. A good example would be the Alberta Energy Regulator, who issues permits for certain oil and gas activity within the province of Alberta. Well, those permits have criteria in them, and if the operator fails to meet that criteria, then they can be held to have violated an administrative rule. You may have noticed some of the language I used in the previous slide about directors and officers of a corporation. I said the directing minds. This is actually a term that comes right out of certain environmental regulations that deal with administrative rules when it comes to corporations. Of course, corporations in law have natural person power. This means they are treated as an individual person, which is obviously a legal fiction, but for our purposes, they could be held to account as the violator of environmental offenses. Now, of course, corporations don't make decisions. It's the people behind the corporations, like the officers, like the directors, who set a policy agenda and make decisions on behalf of a corporation, or even, in some circumstances, employees who make decisions that could lead a corporation to have liability for environmental offenses. Now, first, a few things should be said about a comfort or no action record from government. What do we mean by this? Corporations seek out all the time permission, if you will, to engage in certain activities. Here's a scenario outside of an environmental and natural resource perspective, but we'll clarify what we mean by a no action record. All the time, corporations and individuals in filing tax returns will try to use specialized tax shelters or tools and ways of reducing their tax liability. Instead of waiting until they file their tax return with these creative tools, they might ask the government, and in particular Revenue Canada, in advance, will this be okay in filing our taxes next year? That would be an example of a no action record or comfort letter. Natural resource companies could do the exact same thing while carrying on a project and notifying a government and asking for permission for future activity and asking in advance for some sort of permission and a record of it. So in the event that later on an environmental offense potentially took place, the corporation could raise that as a defense. Back to the point of who is liable behind corporate activity when it leads to an environmental offense. It can be the corporation, but of course, how would you fine a corporation? Now, naturally, it does have profit and it has ways of paying money and of course, upsetting shareholders, so a fine still works as a way of monitoring and regulating corporations. But in very rare circumstances in Canada, you can go directly after the chief executive officers, the directors, or again, that term, the directing minds of a corporation. So there's personal liability for officers and directors who knowingly commit a breach of a law, and there's also liability for corporations. The simplest way to talk about a due diligence defense is to say, did you do everything that a reasonable person would do? Did you take all reasonable care to ensure that in the case of a corporation that it complied with the laws? Now, of course, because the corporation and its activities are carried on by individuals such as officers, directors, and employees, we have to look to the actions of those individuals. Let's talk about the difference in the language that would be used if an administrative offense was brought against the directors, officers, or employees of a corporation versus the corporation itself. First, with the corporation, we would say, did the corporation engage in any environmental offenses caused by the activities of employees or other agents such as directors and officers? If charges are brought directly against individual employees, directors, or officers, we would say, did that individual cause the corporation to engage in certain environmental offenses? So we would need to see some sort of a personal connection to that individual. Now, with a corporation, the due diligence defense can be made out if any of the employees or officers and directors engaged in activities that a reasonable person would have taken on to avoid the offense from occurring. If the charge is against an individual, the individual has to show that they engaged in activities which a reasonable person would have to avoid those consequences. And that's what we need to know about environmental offenses. If you have any questions, let me know. I'll see you in class.